All rise. First District Court of Appeals now in session. All who have business before this court draw near, give attention, and shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Please be seated. Good afternoon and welcome to the First District Court of Appeal. We have two cases on the docket today. We will take them in the order that they appear. The first case today is Grant Stern versus the Florida Governor DeSantis and the Executive Office of the Governor of Florida. Counsel, if you're ready, you may proceed.
My initial oral argument in 5 minutes for the rebuttal.
Yes, so noted.
Thank you. And may it please the court, we are here seeking your honors to reverse the trial court's dismissal of Mr. Stern's public records case. We feel that the trial court improperly denied Mr. Stern an immediate hearing in dismissing the case. It also found that the respondent timely responded to the public records request when it actually did so after Stern filed his lawsuit and denied Stern the right to attorney's fees. And also, we feel that the trial court erroneously rewrote Florida Statute 119.12, requiring a 5-day pre-suit demand letter, basically is what the court was doing before a lawsuit can be filed. And we feel that the statute didn't require that at all, and we feel that the court's order flies in the face of what the intent of the public records law is, the Florida Constitution, and the liberality of Florida Statute 119. In this case, Stern filed or first submitted his public records case or request pursuant to 119.12 subsection B and subsection 2, 1B and 2, on August 20th, 2021. The respondent acknowledged the public records request 3 days later, never filed any objections to the public records request at all, and there was testimony by the affidavits filed by the respondent that they had collected the public records on September 15, 2021.
Counsel, if we construe the statute differently than you propose and find that there is a pre-suit notice requirement, do we need to pass on the issue of whether or not the delay was unreasonable, whether there was an unlawful refusal to produce the documents?
Well, I think it would put an end to the right, if this court says it is a condition precedent, then that condition precedent would put an end to this case. And that's the danger of adding that condition precedent. And the public, if you take a look at the reason why that statute was amended, it was amended in 2017. And it was amended because anyone could just walk up to any public official and make an oral public records request. And if it wasn't, I mean, I could come up and ask you guys, if I meet you coming into this courthouse, say, hey, how much money does the Coke machine downstairs, how much money does the first DCA make on the Coke machine downstairs? And if you don't respond within a few days, we could file a suit. And then that's how disorganized public records cases were. And there were a lot of the O'Boyle cases that I'm sure that this court is familiar with, the city of Gulfstream. There was lots of O'Boyle cases. And so the legislature changed that. It rectified that. And it said, this is what we're going to do. You have to post who is the records custodian and to whom the public record request is to be made. And it has to be made in writing. But that's if the agency designates a records custodian. So that way I don't go and ask you guys or anyone just for the public records request. Or it could be on a website. And then you just click onto the website, So, and it has to be in writing. So that's the way, there's no question of what that public record is.
But is that, correct me if I'm mistaken, is the fact that it needs to be memorialized in writing solely for the purposes of the attorney's fee provision? I mean, I can still make an oral request for public records, correct?
If the agency complies with the statute, it has to be in writing. And what it does is it gives the agency then a 5-day cool-off period to respond. And if you take a look at the statute, and I've got it right here, it says right here that the notice period begins the day the written notice of the request is received by the records custodian. Now, how that got construed into a pre-suit demand letter, I don't know.
Well, the appellee argues that there are certain words here that your interpretation would render surplusage. So, and let's just go through that. So the complainant provided written notice identifying the public record request to the agency's custodian. So couldn't the legislature have just said the complainant provided the public records request to the agency's custodian? That would fit with your meaning, correct?
Well, I think the legislature wanted a 5-day cool-off period after the records request was made. That's why it says right here that the notice period on the day of the notice of the request is received by the records custodian of public records. That's why it has that in the statute. It's saying, hey, listen, we're going to give you a 5-day cool-off period. You make that written public records request, and we're going to give you.
Sure. Okay, so there's another word I'd like to ask you about in
Sure.
that statutory provision, the word complainant. What does that mean? The complainant provided the written notice.
I believe it probably would apply to Stern, the person making the public records request.
But doesn't it also someone who is filing a complaint, correct?
Well, it could mean that as well, but it doesn't say that in the statute. If you read it in
Well,
as a whole.
let me ask you another question.
Sure.
Do you know how many times the word complainant is used anywhere in Chapter 119?
No, Your Honor, I don't know.
I can submit to you it's used once.
Okay.
And it's used in 112, 1 subsection B.
Okay.
So the provision we're looking at. Does that indicate that should mean something about the identity of this person who is asked to provide the written notice identifying the public records request?
I don't see it meaning that this is if it's interpreted that the complainant is the person that filed the lawsuit, then it would mean that the pre-suit notice has to be a post-suit notice, because they have to file a lawsuit and then provide the notice.
What is the complainant complaining about?
I don't know. I don't know why complainant was written in there. But
Well, let's just explore this
Sure.
a little bit. At the time that your client submitted the public records request, was he a complainant at that time?
he was a potential complainant.
But was he a complainant at that time? What would there be to complain about at the time he submitted the request?
If one was going to define the complainant as a person making a public records request, then that's what the definition of that would be. And I think if you read this together as a whole, you'll see that's what the legislature wanted to do. It provided a trade-off. It said, listen, if you have that records custodian right there, post that records custodian, have a website, then it has to be in writing, and there has to be a 5-day cool-off period before an action can be brought. Otherwise, it doesn't make sense. And also, if you take a look at pre-suit demand letters provided throughout the Florida statutes, it's pretty well designated what a pre-suit demand letter is, to whom these pre-suit demand letters have to be provided, and how it is to be provided. Look at the PIP statute, look at the malpractice statute, and the recent homeowner statute. That's all right there. In fact, the homeowner statute, you go on to their website and you just complete a demand letter on a website, a pre-suit demand letter. And it's all set forth right there, telling the person what that's all about. Providing a pre-suit demand letter in this statute will have a chilling effect on people making public records. This is a constitutional right to have public records. We've had this law in the state of Florida for over 100 years. It's well embedded. And what this does is it makes it an extra hurdle, and it makes it more difficult for people to make public records requests and to get their public records. The whole idea is that the respondent here had to promptly provide these public records, and they didn't. I mean, they had these public records on September 15. You know when they gave these public records to Stern? 3 days after they were served with the lawsuit. What did they do that for? Well, they were holding back those records, waiting to get sued. And then all of a sudden, right after the lawsuit's filed, they hand them over without an objection. No objections anywhere. So those hurdles.
How are you, maybe I missed something, how do you conclude that the reason, the very reason that they gave you the records was because of the lawsuit, and that they intentionally waited, did I understand you, to submit these records until the lawsuit was filed?
I'm not saying they intentionally waited, but they waited until 3 days after. They could produce those records. The affidavits say that, oh, we were so busy and we didn't have enough time to comply with the Constitution because we were too busy. There's only one person for 24 million people making public records requests in the state of Florida to the EOG. There was only one person working there doing that full time. So that's understaffing. And then they had the time to go ahead and then produce these records after they got notice of the lawsuit within 3 days, unless that was some coincidence. But that's what they did. Within 3 days, they had it. So that gives you an idea of that they know about they knew about the lawsuit and they responded immediately. So that shows you maybe they could have done this earlier. And all they had to do was give them to Stern in September, as he requested, and there wouldn't have been a lawsuit because he filed the lawsuit in August, or excuse me, October. So had they provided these records in September when they had them, no lawsuit. He would have gotten the records. So, but to go back to the pre-suit demand letter idea that the respondent says is required here. Just think about what public records are, what it's all about. And is this orange on here telling me that it's time for me to sit down?
You are in your rebuttal time.
Okay. I'm within the 10 minutes?
No,
Within-
you are in your remaining 5.
Oh, in my remaining time. Okay, I'm going to sit down, and then I'll let the other side, respondents, and then I'll come back. I guess I got a little over 3 minutes left.
Thank you, counsel.
Okay, thank you.
May it please the court, my name is Daniel Whitehead. I represent the governor in this matter. I would like to address some of the court's questions that they posed to the appellant. First, if the pre-suit notice letter is a requirement under the statute, then yes, this case is over because he failed to submit that letter to our office. And the second issue is, yes, it is a significant sort of leap in logic to infer that we wait for lawsuits before we begin productions of records. In fact, we generally do not like being sued for public records productions. But to the appellant has to prove 3 different things here before he can actually win this case. He has to prove that there was no pre-suit notice requirement. He has to prove that he was entitled to an immediate hearing, even if there were no outstanding legal or factual disputes. And he has to prove that we engaged in unreasonable delay under the statute. To the first legal issue, which is whether or not there was a requirement for the appellant to submit a pre-suit notice letter, our contention is that that is the most reasonable construction of the statute for a number of reasons. The statute expressly states the complainant provided written notice identifying the public record request to the agency's custodian of public records at least 5 business days before filing the civil action. So the first sort of term that's very important, which one of the judges noticed, is the term complainant. It does only appear here, to our understanding as well. And a complainant typically refers to someone filing a civil action. The second sort of issue to look at is the sort of semantics of written notice identifying a public record. Written notice is one term, that's the subject. Identifying, verb. Public record, object. In order for that to make sense, all these terms have to have different meanings. Under the appellant's reading, written notice could be understood as just the public record request, and this would read as the public record request identifying the public record request, which we think would render the terms written notice and identifying both meaningless and redundant.
Well,
And-
I guess, I mean, to appellant's defense, I think, as I understood, one of the arguments pertains to oral requests for public records. And in that case, a written request might be needed under 119.12, but not necessarily, I mean, that's where the oral request would come into play, correct?
So I'm misunderstanding the nature of the question.
Well, as I understood the appellant's arguments that, sometimes you can make oral requests for public records, correct?
Correct.
And then perhaps in this case for the statute, a written notice would be required, but not in the case if there was just a written public records request to begin with.
I see what you're saying. We still think that it would be a particularly odd way to write this. Again, written notice, the typical definition of notice, Merriam-Webster, an announcement, a warning. Sort of the most threatening word in this section is civil action. So the most reasonable referent for notice would be the civil action. So I think the clearest, most reasonable construction would be that this is a warning that we're going to sue you because we want public records. And then also just the context of these provisions. If you look at subsection 2, it states that the written notice requirement's not necessary when the agency does not post its information in a public manifest manner. That's because it's an exception to the general rule. The general rule is that you do have to file the pre-suit notice letter. If you don't file the pre-suit notice letter, you can't get the attorney fees. But this is to facilitate the production of records, that process, and it's also to sort of regularize how public records requests are received by the various agencies so that they can respond to them in the most effective way possible. So to this issue here, yes, we contend that the only sort of reasonable construction for these provisions that gives meaning to subsection B here and subsection 2 is that it is a requirement that you file a written pre-suit notice letter 5 days before you file a civil action identifying the public record request at issue. Now, if that is the case, then this case is over and we win on the merits. And that is because there is nothing left to remand to the trial court to determine. There are no disputes here, no factual disputes about the records that we produced. There are no disputes about redactions because all the records that we provided, I think is something around 580 records. None of them were redacted. And now there would be no legal issue for the lower court to determine that would have any bearing on the legal rights of the parties. And that's because the pre-suit notice letter goes to attorney fees. And if the pre-suit notice letter was not provided, then there's no ability to get the attorney fees.
Well, counsel, just assuming for the sake of argument that we disagree with your statutory interpretation arguments. Let's focus on whether there was CSC in the record to support the trial court's ultimate finding that the delay here was reasonable, and that there was no, in short, there was no unlawful refusal to produce the records. So can you point me in the record what evidence, and I'm emphasizing the word evidence, exists to support that ultimate finding?
Well, we would point to our declarations by Miguel Vassallo and Chris De Lorenz, pages 66 to 69, I believe. There, the public records custodian sort of detail that we have over 100 public records requests. These public records requests.
At the time of the production, though, did they speak to, at the time of the request, how busy the office was, how many staff were responsible for addressing those issues?
It's not clear from the face of the declarations how many we had at the time, but the trial court just had to have substantial competent evidence. I think he was able to make a reasonable inference that we did not receive all of those requests right before we provided the declarations.
So it seems to me that these are really factually driven inquiries, and so why wouldn't a complainant be entitled to a hearing where they could cross-examine witnesses, they could have their own witnesses if needed to kind of flesh out these essential inquiries?
So I guess there's a couple of questions there. Premises have to. So first, we do not think that the immediate hearings apply to attorney fee disputes. We think that those apply specifically to productions of records. We would look at, it says that if you look at the terms of the statute itself, it says that the court shall set an immediate hearing to enforce the provisions of this chapter, and then all the different subsections.
Isn't the attorney fees provision one of the provisions of this chapter?
That's correct, but there are a lot of provisions of the chapter, for instance, penalties that can only be brought by the Attorney General that would not fall under this immediate hearing.
But the statute says whenever an action is filed to enforce the provisions of this chapter, and at the time this was filed, it was enforcement action, was it not? It was seeking to compel production of the records.
Well, again, we would still look at the context that this is in. All four of these subsections deal with, or at least the other three more clearly deal with the production of records. They do not refer to sort of a peripheral question about attorney fees. So we think the most reasonable construction would be that it's to enforce records productions, not the attorney fee situation. But in any case, if the court agrees with us on the first issue, then
Well, I guess even if we do agree, so the next case that comes along where, a party files this pre-suit notice, I'm trying to flesh out whether a hearing is required. And maybe it's not an immediate hearing, but some hearing to establish an evidentiary basis regarding whether the production was reasonably and promptly complied with.
Sorry, could you repeat that question?
Sure. So let's put the pre-suit notice issue aside. Let's just say, assuming we agree with your argument, you get this pre-suit notice requirement, a suit is brought, and the issue becomes, was there an unlawful refusal to produce? And part of the unlawfulness is the timeliness, right? And so in what instances would a hearing be appropriate to flesh out that evidentiary, what seems to be an evidentiary question to me?
We contend that the normal rules of civil procedure would apply when the subject of the record production itself is not at issue. If it's just attorney fees or the other myriad provisions in the public record statute that don't have to do with the production itself, we don't think the immediate hearing is designed for that purpose. We think it's context with the other subsections here that have to do just with record production. Make that clear in context. But again, in any case here, there's no reason to remand for an immediate hearing. In any case, for the reason that we stated, we don't think it deals with attorney fee situations. But we also would note that if the court were to set a general rule that these immediate hearings are required, even when there's no legal or factual disputes that have any bearing on the legal rights of the litigants, that it would only ever amount to harmless error. If a trial court just did not set the immediate hearing and there was absolutely zero effect on the outcome to litigants, it would be completely non-prejudicial. And were the court to read in this way, it would sort of incorporate the canon of, the absurdity doctrine, which is, we contend that this would be sort of an absurd consequence of reading the statute in that manner. That is there. So to conclude on this the situation, we believe that there was no notice that was sent to us. We believe the statute required notice to be sent to us about a suit. And because that was the case, there's no entitlement to attorney fees, which means that there's no hearing that was required, since we believe the hearing only applies to record productions. And even if it did apply to attorney fees, since he's not entitled to attorney fees, the hearing would only amount to a non-prejudicial error were it to not had to have been held. And finally, we do not believe that there was an unreasonable delay in this case. We provided the records within less than 3 months after they were requested. There was roughly 580 of these. Each one of these has to be carefully reviewed. The governor's office has sensitive information. These have to be exempt and redacted. There are penalties if we do not do this. And so this is a careful, meticulous review process. And we receive lots of requests. And these have to be prioritized in a sort of hierarchy depending on all sorts of different circumstances. Thank you.
Thank you, counsel.
Judge Rowe, to answer your question about what is complainant to mean and why is it there, well, let's look at, I had a chance to think about this, and I apologize for the answer I gave you before. Let's take a look at Florida Statute 119.12. It says if a civil action is filed against an agency, and it goes on and talks about the assessment of attorney's fees. So I think what they're doing is they're assuming, they're talking about the person bringing the lawsuit. And then they say, but if that person bringing in the lawsuit then makes a written public records request on the portal or gives it to the designated person, if the designated records custodian is there and waits 5 days, then they can have their attorney's fees. If they don't, no attorney's fees whatsoever. And I think that's what that's all about. They're saying if the agency complies with this section, that public records request has to be in writing and given to the records custodian. That's what this statute's saying, and there needs to be a 5-day cool-off period. And I don't see anywhere the condition precedent. And again, the condition precedent is just a hurdle that's just not there when it comes to prompt response. Remember, Section 119.07 says, and the Constitution says that there must be a prompt response. And adding that pre-suit demand letter in writing that into the statute rewrites the statute. No condition precedent warning to anyone. And it's just another hurdle for people, just everyday people who don't know this. A lot of your Aunt Mitty or a prisoner or just someone off the street wants to write a public records request. How are they going to know about this pre-suit demand letter provision? And it makes it difficult for them. And this is basically for members of the press as well as the People's Court. And they're designed to allow people to come in and make those records requests and to get their records promptly. Now, to talk about the immediate hearing, an immediate hearing was needed in this case to find out if there was a prompt and response to the public records request and see if there was an unreasonable delay. Just because they responded doesn't mean game over for them. There's other things. There has to find out if there is a reasonable delay. And this court has said in Grabsky and Promenade d'Iberville that there has to be an immediate hearing. It said it those times. It said it in the inquiry is if there's an unreasonable delay. It said in those cases if there is an unreasonable delay of any sort, then there has to be an assessment of attorney's fees. In this case, they didn't write us. They didn't tell us, hey, listen, we're still looking for these records. What they did was they acknowledged the records, receipt of the records request 3 days after the initial public records request, and were radio silent after that. Didn't keep us updated. Hey, this is what we're doing. We're trying to find these things. Any of that sort of thing that would give us an idea, hey, this isn't an unreasonable delay. They were radio silent until 3 days after the lawsuit was filed, 77 days after the public records request was made, and gave it to us. And if that's prompt response, then that turns the whole statutes on their head, saying 77 days is a prompt response.
Thank you, counsel. Thank you all.
Thank you. Thank you for your time.
Beautiful
courthouse here, by the way. I'm sure you've heard it before, but it's my first time here. It's a gorgeous courthouse.
I'm glad you could make it.
Thank you.
We'll give a moment for the counsel in the next case to approach. Okay, counsel, before we begin, have you, I will ask the appellee, do you intend to address the cross appeal at OA today? It's your appeal. Okay, so the way it would work would be the appellant would present initial argument, you would respond and present your cross appeal. Then there would be rebuttal in response to the cross appeal, and then you would have rebuttal. Your rebuttal, and then your response to the cross appeal, and then you would have rebuttal. Total. So you needed it. That's why I'm asking the question. Okay, that will help with the sequencing. Thank you, and counsel, you may begin.
Good afternoon, Your Honors, and may it please the Court. Samuel Spinner with Conroy Simberg on behalf of the appellants and cross appellees, Palm Beach County School District and Sedgwick CMS. If I could please reserve 7 minutes of my time for my rebuttal and cross argument as well.
So noted. Thank you.
Thank you, Madam Chief Judge. So in the main appeal, appellants respectfully request that this Court reverse the JCC's order granting Johnson's petition for authorization for a second opinion, because Section 440.13, subsection 3, does not apply under these circumstances, and even if it did, the JCC still erred because Dr. Ryder testified that he was not and did not refer Johnson for a second medical opinion with a different orthopedic surgeon. This area of the law is pretty well developed. We all agree that one provider's authorization for a second opinion with another provider constitutes medical care and a referral for medical care under the statute. And we also agree that the failure of the carrier to respond within 3 or 10 days, depending on the nature of the referral, waives only the defense of medical necessity, but does not waive any other defenses, as this Court has recognized. But this case presents an interesting issue because in every other case that we've seen on this, there was never a dispute that the provider had actually referred the claimant to another provider and was sticking by that recommendation throughout the entire case. Most of these cases, as your honors have seen, come down to the issue of what defenses were we raising, did we respond timely, and factual issues of that nature. But this is the only case where you have a provider telling the judge, I did not refer Johnson. All I did was essentially document his request to me, and I don't think that referral's not that it's not medically necessary, but that I did not intend to refer Johnson to.
Is that the way you would characterize the DWC 25? That it was just reporting what the claimant had asked for?
Yes, Your Honor, based on his testimony as to what he meant by what he wrote in the DWC 25, and I think that's really where the rubber meets the road in this case.
Well, how was the insurer to take the DWC 25 when received, when it specifically says that it's medically necessary, that it's a written request for insurer authorization, and that it says second opinion?
Understood, Your Honor. So the adjuster in this case certainly took a bit of a gamble because she, based on her experience and her dealings with Dr. Ryder and her understanding of the law, read this and read the progress note, and he said, you know what, I don't think that this request came from Johnson. I think it came from Dr. Ryder. I think it came from Johnson. And had she been wrong, we wouldn't be here today. If she had made the wrong guess and it turns out Dr. Ryder came in and testified, no, I was the one who referred him, then we're in a different case. And so the question is really, does the court care more about form or substance? Does the court care?
Well, let me phrase the question this way, at least for purposes of my question to you. I mean, it seems like you're asking us to rely on Ryder's testimony that came long after the request was made to the carrier to kind of like bootstrap the initial notice. And so I guess going back to Judge Winokur's question, if we look at the form alone, do you concede that that is an unambiguous request for a second opinion from the physician?
If you look at the form alone, I think that's fair, but it literally says second opinion with no elaboration. And that's really what we're raising here, is that this was in response to a petition for benefits. We have depositions. We have a full-blown final evidentiary hearing.
Well, I understand, but given the time deadlines that are in the statute, those deadlines, the clock starts ticking at the moment the carrier gets this form or gets notice of it. And so the carrier, the adjuster, when she looked at it, she had 3 or 10 days to make a decision based on that documentation before her. And if you've conceded that the documentation provides an unambiguous request for the referral, then why isn't that the end of the story?
Because I think the court should look at the totality of the actual evidence that was adduced in the case and should not, for lack of a better word, put on blinders and only look at the form and not at the substance. I think there's support for that view in the Lunsford case, where even though the claimant filed a petition for benefits attaching a letter from a doctor in which he recommended a second opinion, and even though the carrier did not respond within 3 days, the court specifically said we can't ignore everything that we know about what happened in this case and what preceded the petition for benefits. And that's similar to what we have here, where we have a doctor saying, here's what I meant, and here's, this is what.
But that's not what he said. I mean, I'm really struggling with the adjuster has to make a decision based on what she is provided. And we know that what she was provided unambiguously states that there was a referral for a second opinion. And so, I mean, I'm struggling with the concept that we can kind of look at testimony after the fact to kind of clean up any mistake, perhaps, or maybe he didn't intend to fill out the form that way, but nonetheless he did.
And I think that the workers' compensation system encourages parties to correct mistakes, because we can have a situation where a doctor makes a mistake. Oh, that wasn't Johnson. This was Johnson. I thought this was a different claimant. The doctor could change his opinion by the time we get to a petition and a final hearing and say, you know what, an MRI came out and I reviewed that, and based on this new evidence, I don't want a referral at all. Not that it's just medically unnecessary, but that I wouldn't make the referral based on this evidence. And that really gets back to our theme of the substance over the form, because this didn't happen solely in the context of there was a DWC 25 and that was it. they had to file a petition for benefits. We get to raise defenses. We took depositions. We went to a final hearing. There was additional testimony at the hearing. And when that happens, the JCC should take all of the evidence and determine, is there a referral in fact, or is there a referral based on a technicality? And I don't think that this court should encourage judges and judges of compensation claims to ignore evidence as to what a doctor meant and to go solely with what is written in a form, which is the word second opinion without elaboration. And again, we could have been wrong in this case, but we happen to be right that the genesis of this opinion did not come from Dr. Ryder, and he's not an attorney, he's a doctor. He wrote this in the form, and maybe he didn't understand the full consequences legally of what that would mean in this case, but the court should encourage viewing all of the evidence. We have all of this testimony, and we're asking really for a simple rule in that if the evidence shows that the doctor did not make or is not making a referral, that should be the end of the analysis.
And before you get into your rebuttal time, I did want to ask a question again, respecting the way this case was tried before the JCC. Who does the carrier owe the response? Does it need to go back to the doctor who's making the referral, or why isn't it enough that the carrier responds to the claimant or the claimant's attorney?
The case law and the statute talk about have to respond, and it's always been responding to the doctor. Now, certainly that's a point in our favor in that we did respond to claimant's counsel within 3 days, but we didn't make the argument that that was a response to the provider under the statute, and that's what the case law has talked about, is you have to respond to the doctor's office. And had we done that, maybe we would have clarified this earlier. But I think there's also the argument that under the JCC's view, our clarification would have been irrelevant because he wrote second opinion. And so if he writes second opinion, if we respond, all we could do now is raise medical necessity. And what we're asking for is for the ability to argue that there was no referral in fact to begin with. And there, as I said, there's situations where things can change, mistakes could be made. Taking it to the very extreme, someone could forge a DWC-25 form, and if we don't respond in 3 days, we can never make the argument that that's what happened. And so because this came in on a petition for benefits, asking for this opinion, the court, as an element of that claim, necessarily had to find that a referral existed. And when Dr. Ryder came in, he was unequivocal in his testimony. I didn't make the referral. I documented Johnson's request. It's not medically necessary. There's nothing another orthopedic surgeon could do that I'm not qualified to do myself, which is why he said that he wouldn't have made this referral. And so while he might not have understood the legal ramifications of what he wrote in that form, our position is that should not have been the end of the analysis, and that this court should craft a very simple rule that if the evidence does not show, once we have the petition and once we have all the proceedings, the evidence doesn't show that a doctor is actually referring the claimant for a second opinion, that should be the end of the analysis, and the petition for the second opinion should be denied because the existence of a referral is, of course, an element of the claim for the second opinion. And so for those reasons, that is the approach we'd ask this court to adopt, and we'd ask that Your Honors reverse the JCC's order to the extent it grants Johnson's petition for the second opinion, and I'll reserve the remainder of my time for the rebuttal and the cross appeal.
Thank you.
May it please the Court. Ken Schwartz on behalf of the claimant, Mr. Johnson. This seems to be thematically grouped for the cases today because you were talking earlier about what constitutes a written request in a certain circumstance. Obviously, I'm not going to comment on the other case, but I would submit that in this situation, it seems pretty clear. As outlined in the the answer brief of the claimant, Dr. Ryder was presented with an opportunity to complete a form that he's supposed to be using at the end of every authorized workers' compensation visit, the DWC-25 form. It has clear instructions that go with it, a separate set of instructions that are promulgated by the Florida Administrative Code, Rule 69L-7.720, I believe it is. It's cited in the brief. And along with in those instructions, it clearly says that you are supposed to fill this out completely and that all the information that you put in this is supposed to represent, including your management/treatment plan. And in that section of the DWC 25 form, Dr. Ryder clearly wrote the words second opinion. It doesn't call for a narrative. It doesn't call for anything other than writing in there what you believe to be medically necessary. That it even says on the form itself that the proposed clinical services that are completed in that section are deemed medically necessary.
Well, counsel, I mean, we know that the adjuster did see this and say, wait a minute, there's a problem here right away. Didn't actually contact the doctor. I believe she based it on the report, looked at what the doctor had written about the referral or non-referral, whatever you want to call it, and said, wait a minute, this isn't a referral. This looks like it was initiated by the claimant himself. It doesn't look like it was initiated by the doctor, and for that reason, we're not going to pay it. So even though I agree that the form is crystal clear, the adjuster certainly thought the issue was open based on what the report said. So why can't we rely on that additional information that the adjuster did rely on?
The shortest version would probably be to refer you to 440.015, the legislative intent section of the statute that says this is supposed to be a self-executing system. It's supposed to ensure the quick and efficient delivery of benefits to the claimant. And the other case law interpreting, that statutory, the case law interpreting that statutory section refers to fundamentally the workers' compensation system being an employer-carrier monitored system. Well, if the adjuster had any question in her mind as to what Dr. Ryder meant when he wrote on this mandatory form, second opinion, without any equivocations to it, she should have picked up the phone and contacted him, written him a letter, done something to contact him, but she didn't. To quote opposing counsel, the adjuster took a gamble. She gambled, and it turns out that although the doctor did later on make a statement at the deposition months later that, no, I was really doing this at the initiation of the claimant, he nonetheless had the opportunity from the very beginning to not put on the DWC second opinion, to simply note somewhere that the claimant made a request for a second opinion, and I either have no comment on it, or I don't think it's reasonable or medically necessary, or whatever else the doctor might have wanted to say. But what he did do was he put on the form that it's a second opinion in the section that indicates this is a medically necessary claim for care, and the adjuster did nothing in response to it. So if the adjuster does nothing in response, are we supposed to then go ahead and say, all right, the carrier did nothing, they didn't waive it, so the statute really means nothing if they don't respond within 10 days. Instead, we, the claimant's bar, are supposed to set the deposition of the doctor to make sure that he really meant what he put in writing on a form that's, as you say, clear and unequivocal. And in every single case, we are no longer going to be considering the quick and efficient delivery of benefits. We're going to litigate every single referral to a specialist.
I agree, but I mean, surely this isn't a case where you're forced to relitigate or re-ask what is something that's already clear. Again, there was already evidence at the time that the adjuster believed that this wasn't authorized based on Dr. Ryder's report. So doesn't that make a difference?
I'm not quite sure what you're asking. Does it
Well,
make a difference that there's additional information? Yes, but we have something that's crystal clear on its face that shouldn't be ignored. Or if it is ignored, it's at the peril of the employer carrier.
Counsel, let me ask it this way. This is an experienced adjuster. She clearly had concerns based on the progress notes or whatever you call it. What response would have been sufficient under the statute to not waive the medical necessity defense?
I think she very easily could have taken the email that she wrote back to counsel in response to his initial request where he forwarded the DWC 25 and simply put a fax cover sheet and asked, is this medically necessary? That would
So
have
the
taken her an
response
extra
would
minute.
go back to the physician, to Dr.
Ryder.
Okay. And that kind of goes to a question that the Chief asked appellant's counsel is there any statutory authority for this response to go, to the physician as opposed to the employer carrier's counsel? I mean, or does that originate from case law?
I think that it's a plain reading of the statute because the statute says that the carrier has to respond to a request. Well, where does the request come from? I guess that's the crux of the appellant's argument here. The genesis, if it came from the claimant, then it doesn't constitute a request that has to be responded to. But in this case, that's a moot point because the doctor did, by virtue of the DWC 25, in fact, make an unequivocal request for a second opinion. Just because the narrative says something that makes that a little bit more ambiguous doesn't change the fact that he did make a request. So if you're looking at when a doctor makes a request, then a response must come to something. So it would go to the doctor in response to the request from the doctor. And that comes straight out of the statute, as I read it.
What happens when the employer or carrier grants that request?
When the employer carrier grants the request for a second opinion?
Yeah, what's the process, generally speaking?
Generally speaking, they pick a doctor because they still maintain control of medical care in most cases. They would say that Dr. So-and-so is now authorized for a second medical opinion. The claimant would then go see that doctor at the carrier's expense, and depending on what the referring physician wanted, he could then set up his own protocol. In this case, according to Dr. Reiter, what he said was the claimant should return in a month or after the second opinion. So that would have been what happened in this case. What really happened, and this is outside the record, so I don't know if you can feel free to do with what you will, but the claimant, because the benefit was denied, the second opinion was denied, he went and got one on his own. He then brought that second opinion back to Dr. Reiter, and Dr. Reiter, in fact, recommended a third surgery and performed it. So that's not typically what happens. They don't typically go outside the system. Typically, the carrier would say, okay, it's either we failed to respond, so we waived our response of no medical necessity, or fine, you can have the second opinion because we think it is reasonable under the circumstances. You go and you get an opinion, come back, and then the doctor just deals with it in the ordinary course of his medical opinions. So I don't think the statute sets it forth, and in fact, that's why there is case law like Lombardi from, I want to say 2004, that was entirely about the question of, well, does the workers' comp law provide for a second opinion? And they said as long as it's reasonable and medically necessary, then yes, that's available. But that's because of a lack of clarity in the statute setting one forth. It's certainly not a right under the system, if that's what you're asking, Judge. So as the judge pointed out below, this really is a very narrow legal issue, and I believe it's a very narrow factual issue, too. It's a matter of, was there a request, and does it matter where it came from? And as Judge Hedler pointed out, he gave 3 different reasons why he thought that the second opinion should be granted. I believe the second one was, does it really matter where it comes from? And his example was, what about things like commercials on TV that advertise medicines? Or what if your next-door neighbor says, oh, I just had one of these done by a so-and-so specialist, or I had some other medical care. And the injured worker goes into the doctor, and the authorized doctor, and says, hey, I know you've said that you want me to stay on Neurontin or go through more physical therapy or try a TENS unit or whatever, but somebody I know, somebody outside this medical office presented me with some idea, and I want to run it by you. The doctor then has the opportunity to say, yeah, that's a good idea, or that's not a good idea, or you know what, sure, why not?
So let me ask you about appellant's extreme hypothetical, but we still need to find the kind of the boundaries of our holding. What if you had a forged form, which obviously at the end may not have come from a physician and would not be medically necessary? If the employer carrier doesn't respond within the timelines, do they waive medical necessity even though ultimately it's uncovered it was a fraud?
So you're asking, should they contemplate whether something is unlawful, it's a fraudulent document, and use that in their determination of whether or not to respond?
Well, no, I mean, I think, and counsel can correct me if I'm mistaken, is I think the example was if you have, so your argument is unless you respond within the time period, you're going to waive the defense of medical necessity, right? So what if you have a document that facially appears legitimate, but ultimately turns out to be fraudulent? But if the employer carrier doesn't respond, do they ever have an opportunity to come back and say, no, wait a minute, the evidence now shows a physician didn't write this, it's not medically necessary?
I would guess that, and this is kind of an out-of-the-box hypothetical, but if it were in some way the claimant's insistence that this fraudulent activity took place, then I would think the JCC has the remedy of striking that second opinion or making some modification to what evidence the JCC will consider in contemplation of further workers' comp benefits that were requested by the claimant. If this had absolutely nothing to do with the claimant whatsoever, I fail to see why the claimant should be prejudiced by it. If somehow outside the claimant's knowledge some fraudulent form is presented to a carrier that says that a medical benefit is necessary, the medical benefit is provided to the claimant, should the JCC be allowed to say, you know what, no, I'm going to take those things away from you now, even though you had nothing to do with it? So I think we're getting way outside of our facts here, but to the extent that it's the claimant's fault, then the claimant should be held responsible for his actions. But that's not the case here, and it's certainly not the case frequently or even regularly. I think the JCC has powers. The judge can do all things conformable to law pursuant to 440-33 sub 1 to maintain order in the progress of the case. So there's also the rules of civil procedure on things like fraud. So if there's a judgment rendered and it turns out it was fraudulent, well, the judge has some powers. But here what we have is merely an ambiguity, but I think it's an easily resolved ambiguity because, as we discussed, the DWC is crystal clear on its face. And to the extent that counsel argues that perhaps Dr. Ryder didn't know what he was doing, with all due respect, I think that's disingenuous because Dr. Ryder has been doing this a very long time, not as long as the adjuster has been doing this, but he's been practicing medicine in South Florida, handling workers' comp cases for many years. I can't speculate on how many of these DWC forms he's filled out, but I'd be willing to bet it's in the thousands, if not at least the high hundreds. And he knows. He knows what he has to do. He knows what the rules are. The rules are published. We're all responsible for following the rules that we operate under, and he voluntarily takes workers' compensation cases. And so he should be tasked with knowing that when he fills out a form that clearly says on it that whatever you put in this space is going to be deemed medically necessary, if he doesn't want it to be deemed medically necessary, he shouldn't put it there. So I see that my time is almost up. I reserved time earlier before, but the cross-appellant will rest on the briefs.
Thank you, counsel.
May it please the court. The point I was making with the extreme hypothetical is that the plain language of the statute and this court's law interpreting that statute says that the only defense that's waived by not responding is the defense of medical necessity. It does not waive any other defenses. And our position is that one of those applicable defenses is the fact that there is no referral in fact from the doctor, whether that's due to changed circumstances, whether that's due to a mistake, or again, the extreme example of a forgery. To find otherwise would to expand the statute beyond its plain terms and to say that you not only waive medical necessity, but also waive the right to ever challenge whether the referral actually exists. And that's why I brought up that hypothetical, because this doesn't happen in most cases. In most cases, the doctor makes the referral and they never retract it, which is why this is a case of first impression. But under the facts of this case, we should have been able to present the argument that Dr. Ryder was not standing by what was in his form, that he was not referring the claimant, and that's a separate issue from medical necessity. Whether a referral exists is not the same as whether that referral is medically necessary. We believe that that's an element of the claim as well as a valid defense, and that we should be able to.
Let me interrupt you. So are you saying that this form was not a referral at all because it didn't name another physician, that it shouldn't even be considered a referral, and therefore you should be allowed to challenge whether it actually was a referral at a later time, even if you're not challenging medical necessity?
Yes, Your Honor. I think that, I'm not saying that it was not a referral based on what was in the form, but that it wasn't a referral based on what Dr. Ryder testified to and his opinion and what he meant by what he put in the form. And what we're asking for is for the opportunity in these cases to be able to, when the circumstances support it, to be able to argue there is no referral, the doctor's not standing by what he wrote. That could, again, be due to a mistake. It could be due to a change in his opinion, and that happens all the time. Doctors might make a referral, and by the time we get to a hearing or a depo, they might have additional evidence. They might have reconsidered. There could be new developments in medicine. There could be all host of reasons why they're no longer making the referral that they made. And we believe that because this court has already interpreted the statute as saying the only waived defense is medical necessity, we should retain the right to, under the circumstances in the rare case like this where it happens, to be able to argue, we've looked at the testimony, we had a full-blown evidentiary hearing, and the doctor is not referring the claimant, and under those circumstances, we should be able to make that argument. And in this case, we did, and the JCC rejected it. For that reason, we believe that that should be reversed because in reality, Dr. Ryder is not recommending at the time a second opinion. And just briefly as to the cross appeal, I know counsel rested on the briefs. The JCC's order is supported by competent substantial evidence in that Johnson testified there was multiple reasons for which he retired. He voluntarily explained this issue with his wife pestering him daily to retire and wanting to travel with her, and the JCC took that in connection with his other testimony and ultimately determined that Johnson voluntarily retired, which was a superseding cause of any wage loss, and that he was not entitled to any TPD benefits because he voluntarily chose to retire. He didn't look for another job. He's never returned to work. And I think most importantly is that he testified he would not have accepted any offer even if we had made it or made it more times. And so I think the JCC's order is well reasoned and that competent substantial evidence supports it with regard to the TPD claim. And so for these reasons, we ask that Your Honors reverse the JCC's order as to the second opinion and affirm the JCC's order as to the claim for TPD for that 3-month period.
Thank you, counsel.
Thank you, Your
Thank you
Honors.
both. This court is adjourned.
All rise.